case to come before the court is Brown, guardian of Etta Harris versus ManorCare. I guess I can just say good afternoon, Joe.
Good afternoon. It's official.
Yes. Go ahead.
May I approach?
Sure, you can approach. I was just kind of waiting for the noise to die down, but you're fine.
Oh, sure.
Come on. A loud bunch today. All right. You each will have 15 minutes to present your arguments in the court, and you may reserve up to 5 minutes if you so desire.
I'd like to reserve 2, please.
That's fine.
May it please the court, Martin Galvin on behalf of Appellant ManorCare Health Services. Your Honors, as the court is aware, this is an appeal from a nursing home liability lawsuit that was filed on May 24th, 2013. This is an interlocutory appeal from a discovery order that the trial court issued. The order in question ordered the production of information and documents relating to other incidents of a similar nature by the plaintiff of the decedent's roommate, as well as by any other resident of this facility over a 10-year period. The reason these records were sought is because there was allegedly an assault. This is unfortunately not something that is terrifically uncommon in the nursing home context. One resident assaulted another resident. So they're looking to get records, not only of that resident, but from any other resident who was involved in a similar context or a similar situation over a 10-year period.
And the trial court said you can't get any medical records, right?
Correct.
But said you can get incident reports.
They said you can get personal records. What the trial court actually said is the plaintiff's entitled to discover information and documents relating to Mrs. Harris's care, other incidents of a similar nature by her roommate to others, or other incidents of a similar nature by others while residing at the nursing home, all which may show knowledge by ManorCare or its agents of an ongoing problem.
Okay, and so how is that privileged?
Because the statute that's in question, Revised Code 372113, makes no distinction between medical records and personal records, or medical records and incident reports. The court didn't say all you have to do is produce incident reports. They say you have to produce all information and documents that pertain to any incident of a similar nature by her roommate or by anybody else over a 10-year period. We're not talking about banking records. We're not talking about estate planning records. All of the records in ManorCare's possessions are medical records. That's what they are.
Well, here's the thing that I was thinking of when I was reading these briefs. It seems to me that ManorCare or any facility, as far as that goes, could just put incident reports, we'll call them that, any documentation of assaults or some kind of attack or something with residents. They could just put them in the resident's medical file, and then you don't have to turn it over. That's not truly a medical. Isn't a medical record, they have bipolar, they have schizophrenia, they have dementia, how many times they had a bowel movement that day? Treatment, thank you. How is that a medical record that this person has attacked somebody previously?
Well, what the statute says, Your Honor, is that the patients, and this is under the Ohio Nursing Home Bill of Rights, patients have a right to privacy for medical records and personal records.
Okay,
So all the
what is a
examples,
personal record?
I think a personal record is anything that's contained in the patient's file that relates to their person, to their, it's hard for me to stand up here and say what record would be in this file that's not either a medical record or a personal record. Because that's what they're there for. They're there for treatment. They're there because they can't take care of themselves.
I presume that depositions will or have taken place. Am I correct in the procedural posture?
I don't believe any depositions in this lawsuit have taken place. Mr. Dixon will correct me if I'm wrong in that.
So there's no other way, in your judgment, to obtain the information you need other than the physical records?
Correct. I mean, they have asked for a lot of information, and there was a delay because of the an extreme breadth of the information that was requested, but, depositions can be taken and these questions can be asked. I think that is an alternative way to get this information. They could go to the other patient, Ms. Taylor, or to her family, or to her guardian, and they can request the records that way. What they're doing instead, and this is a pattern, is asking us to turn over the records, and it's our position that we don't have a legal right to do so. The Nursing Home Bill of Rights in Ohio says you have a right to confidentiality, and it says if these are going to be ordered, or if these are going to be disclosed, you have to consent to it. We haven't had consent.
So you stated that all records are medical records. So would you be suggesting then that if, say hypothetically, an assault did occur, or somebody was injured, so you're telling me that if the police came to investigate an actual assault, there would be no records to get because they would be considered medical records, and so you couldn't even get anything about what happened because it would all be medical records, right? So there'd be no criminal prosecution because they couldn't get any records.
Well, I mean, the criminal prosecution wasn't an issue in this case.
I'm just saying, though, you're telling me that all records are medical records.
What I'm trying to say is that the records are either medical records or personal records, and that under the statute, there's no distinction. They're treated identically.
So if you're a victim of an assault, it's a personal record and still protected.
Well, if you're a non-party in a lawsuit, it's protected from disclosure. They could sue Ms. Taylor, or they could sue her estate, and they could get these records. They've chosen not to do that. Instead, they said, we're going to sue you, ManorCare, and we're going to say you have to
They're
produce.
suing you, I guess, because you're the one supposed to be protecting those residents, right?
Protecting the residents?
Protecting the residents, sure. Isn't that your role? And part of it, it's not just treatment, but it's also protection. I mean, it doesn't do any good to treat them if they're subject to assault every 2 seconds.
It absolutely is, and there's a standard of care that has to be
Right.
met, and that's the issue that's going to be determined when this case goes to trial.
Well, you said, I'm only responding to your answer to Judge Whitmore, that you said they chose not to sue the resident. That's their choice. They're saying, whether it's right or wrong, I have no idea. But they're saying you're responsible. And we're
Right.
going to try to, and we want information from you to determine whether we can really prove our case against you.
Correct, but our position is that all of the case law out there talks about the non-discoverability of these records from third parties. If they made her a party, then they can get it from her directly, or she would probably have to sign some
Well,
sort of
how would she
authorization.
have, I'm sorry, I'm not sure I understand, how would she have a record personally of either herself or anybody else that is engaged in this activity that you haven't protected people from, or that you have knowledge of?
But she wouldn't have records pertaining to somebody else, but she would be able, she'd be authorized to consent to the disclosure of these, and she'd likely have to. When people get sued, they have to consent to the disclosure of the medical records all the time. Or when somebody files a lawsuit, they consent to it. It's not my job to tell them how to get the records, and I'm trying to give some hypotheticals to the court, but the way the law is written is if it's a non-party, we just can't produce it. The Roe versus Planned Parenthood case, that's not an agent case, that's an Ohio Supreme Court case from 2009 that speaks directly to this issue, and they said that without authorization, you can't release these to a non-party.
Okay, so you don't have any, I'm sorry, you don't have any separate records of incident reports or anything regarding assaults of your residents?
There are incident reports, and there's probably incident reports that are not included in the records. But if it was that narrow, that was something we could deal with the trial court, but that wasn't how narrow the request. The request was much broader.
Did you try to narrow it?
Yeah, there was...
There was a conference is required to try and work this problem out?
There were multiple letters that went back and forth, and then the issue was brief. They filed a motion to compel.
Did you turn over those records?
I can't tell you what the status of that. I didn't handle it at the trial court level. I think some records were turned over before the court's order. There was a court order in late May. Then there was a motion for reconsideration. This appeal was filed in June. There was, I can tell you, I can represent that there was a concerted effort to comply with all of the discovery requests.
So your position is that any incident reports that you prepared as a result of the alleged assault or assaults on other patients or any physical confrontation that you would have to either record or or record as an incident pertaining to the residents at your facility, that you don't consider those privileged?
Well, to the extent that that incident report existed outside of the patient's file, I think that there would be a good argument that it wasn't privileged. It's not the issue that's before the court here today. It's not the issue that's before the trial court.
I'm not sure I understand why it's not the issue before the court.
Because the request was much broader and the trial court's order was much broader. The trial court's order said any information in any document relating not only to this incident, but to any similar incidents. So if you look just at your standard nursing home liability cases, you're going to have bed sore cases. Can they ask for similar incidents of any other patient for 10 years? You're going to have people falling off of toilets. You're going to have people who are dehydrated. I mean, for lack of a better phrase, the slippery slope as this presents is very real.
Well, actually, I'm not sure why would that be a problem if you're not disclosing. I mean, there could be multiple ways, I guess, of handling it. If you're not disclosing the individual's name of the resident, don't you, as a matter of fact, even have to report that to the Department of Health? Because I can go on a website right now, to Medicaid website, and look at your findings with your nursing home in regard to bed sores, in regard to accidents, in regard to assaults.
They could look at surveys, yeah, and I'm sure they have. But no, there's you can't simply redact the name. That the Roe case stands for that proposition, that the NAR case stands for that proposition.
But my point is, and you may be right about that, but my point is, there are ways of getting this information, and you do have to disclose it, right?
There is, no, well, you don't disclose specifically what happened to any patient without their authorization. There are surveys. The reason probably that they're not using the surveys is because there's restrictions on how surveys can be used in civil litigation. And Mr. Dixon probably feels that he'd be restricted using the information in that manner, and he'd prefer to get it this way because it would give him more options as to how to affirmatively use that information in this lawsuit. But those surveys are out there, that information is out there if he wants to take advantage of it. But what Revised Code 372113 speaks of is the rights of residents, and it says you have the right to confidential treatment of personal and medical records and the right to approve or refuse the release of these records. And that's really what this comes down to. What does that right mean? They're saying, well, that's not a privilege, it's just a duty. To me, that is a privilege. There's no distinction to be made. And even if it was merely a duty, does that not still put a legal duty upon my client, ManorCare, not to release these absent authorization? And
If you were asked to go through those records yourself and supply certain summaries, would your objections dissolve?
I guess theoretically it might. It depends how it was done. You know, there couldn't be any identifying information. I guess that would be a situation that's going on redacting. If they just want to say, you know, this is how many incidents we've had of a similar nature, then, you know, perhaps that would be a compromise.
It might be a start.
Right. And it's just not where we were. Instead, you know, we filed the appeal, they're moving for sanctions, they're saying it's frivolous, all that stuff. It's not frivolous. I mean, if you just look at 23-1702, it talks about what the physician-patient privilege is. And it's not a doctor giving you a diagnosis, and that clearly is protected. But it's much more. It's a communication for acquiring, recording, or transmitting any information in any manner concerning any facts, opinions, or statements.
And you're into your rebuttal time, all right.
Those are the parameters of the privilege that's at stake, and that's separate from the nursing home Bill of Rights.
Good morning, Your Honors. Blake Dixon for the plaintiff and the appellee. So we propounded discovery on November 26, 2013. And as I stand here today, I don't have a single answer to a single interrogatory. I don't have a single piece of paper. I don't have one letter, much less a word of information. Your Honor, you asked if we'd asked for this information different ways. We definitely did. We propounded an interrogatory which asked for the information in addition to asking for the records.
You got the same answer, that it was statutorily prohibited and illegal.
No, Your Honor, we got nothing.
You
So-
got no response.
No response. We propounded just...
And you had admissions?
That I don't know. I know we had interrogatories requests for production of documents. I don't know off the top of my head. We normally propound admissions, and so those may be out there. But we propounded discovery on November 26, 2013. The court gave the defendants until January 23, 2014, more than a year ago, to answer discovery. And 4 months later, they hadn't objected, they hadn't responded, they hadn't raised anything. They had just done nothing. So that's when we filed our motion to compel. And one of the things the trial court said in its entry was that the defendant's objections are waived. And the court said you can't sit around for 4 months after I've given you an extension and then raise an objection for the first time in response to the plaintiff's motion to compel. One of our frustrations here, and one of the reasons we're asking for this appeal to be dismissed and we're asking for sanctions is because we encounter over and over again appeals for the sole purpose of delay. There is no basis to this appeal whatsoever. Counsel cites 3721.13 and says, this is the Nursing Home Bill of Rights, and it clearly says that the residents have a right to keep their records confidential. It says, except as required by law. There's a specific exception in 3721.13 for subpoenas, for court orders. There's no question that that exception exists. There's no basis to that argument. It's completely frivolous. And there's not a single case that defendants have cited where nursing home records are held to be privileged when a court has ordered them to be produced.
So a record that might contain treatment, medical treatment, would be privileged, but the rest of it wouldn't be?
So that's a good point, Your Honor. The only privilege raised in response to our motion to compel was the physician-patient privilege. That's it. The physician-patient privilege just applies to communications between a doctor and a patient for purposes of diagnosis, treatment, prescription, or actions on behalf of the doctor for the patient or a dentist.
The statute he's talking about refers to general records about the patient.
3721.13A10 says that a resident has the right to confidential treatment of personal and medical records and the right to approve or refuse the release of these records to any individual outside the home, except in case of transfer to another home, transfer to a hospital, transfer to another healthcare system, as required by law or rule, or as required by a third-party payment contract. So while in general they can't just go giving out records willy-nilly, there's a clear exception for required by law, which is exactly what a court order is. So there's no question that 3721 doesn't prevent them from producing these records. They didn't even raise 3721.13 in their brief in opposition to our motion to compel. The only thing they raised was the physician-patient privilege. I can tell you as a nursing home lawyer who's handled hundreds of nursing home cases, there's about that much physician-patient information in any nursing home chart. Because the only thing that is in there is, I'm in the room with my doctor and I say, hey, my elbow hurts, and he says, oh, let me look at it. Oh, you have a bruise. That's a physician-patient communication. Nurses' notes aren't privileged, the medication administration record isn't privileged, the treatment administration record isn't privileged, et cetera, et cetera, et cetera. And, as you pointed out, even if the records are privileged, the underlying information is not privileged. So that's why we asked for it with an interrogatory, as well as with request for production of documents. In addition to all of that, there's a statutory duty on behalf of anybody, any healthcare professional, doctor, nurse, et cetera, to report abuse, to report, any kind of a trauma. And so obviously, if Marilyn Taylor beat up another resident, then that has to be disclosed. If Marilyn Taylor punched a staff member, there's no justification that that's privileged. In addition, the defendants have completely failed to carry their burden. The only way they could even bring you a claim of privilege is if they had a privilege log, and they said, hey, here court, here's a document, and let me tell you why it's privileged. And then trial court could do an in-camera inspection, make a ruling, and then you guys could review that ruling. That hasn't happened. The defendants haven't identified a single piece of paper that could possibly be privileged, so there's no way they can carry their burden. They have filed this appeal to delay this case, and they have succeeded in delaying this case for almost a year, which happens in case after case after case. They just call something privileged, and they take an interlocutory appeal. That's why we moved to dismiss it, and this court properly, the magistrate properly, raised that issue when the appeal was filed. We briefed it, and unfortunately the magistrate deferred that issue to this argument and to the decision by the court. I would like the court to dismiss this appeal, and I would like the court to sanction the defendants and their attorneys for wasting time. You know, I try to prosecute nursing home cases on behalf of residents. This lady was a resident in this nursing home. They put her in the room with a woman who had a history of violence. She tried to kill her with a coat hanger. She barricaded the door. She took a coat hanger and she wrapped it around Etta Harris's neck and she tried to strangle her to death. She was unsuccessful. The nursing home called Etta Harris's daughter and said, hey, your mom's had a minor altercation with her roommate, but she's just fine. And they didn't even send her to the hospital. Her other sister went over, the other daughter went over, saw mom, mom's all scratched up. She takes mom to the hospital. The nursing home never told either sister that the roommate tried to strangle her. For some reason, the nursing home disclosed that to the hospital, and the sisters found out from the hospital that her roommate had tried to kill her. And so this is a case of attempted murder, where my client was almost killed, my client who's passed away now, but at the time was almost killed by her roommate, and we're looking for information about the roommate, and the defendants are doing nothing more than delaying this case and hiding the information. The only privilege they raised through the trial court level, which is the only privilege in front of you, is physician-patient. And as the court is clear, and as we clearly briefed in our merit brief, you have to carry the burden of your privilege with specificity. You can't just say, well, the stuff they're asking for is privileged. You have to say, here it is, and here's why it's privileged. They haven't identified one document that's physician-patient privilege. As you pointed out, an incident report certainly isn't physician-patient privilege. A piece of paper in a staff personnel file that says, you know, aide Mary Jones had an altercation with Marilyn Taylor where she yelled at her or threatened her or kicked her or punched her. That's not privilege. I just finished a trial of this case out in Lorain County. Exact same thing. Roommate beat the living crap out of my client, broke all the bones in her face. We got all her medical records in that case because that was entirely irrelevant.
You want not just the records pertaining to the roommate and perhaps the trouble she may have caused, but you want all trouble.
No, Your Honor, that's not true. No, as a matter of fact, as counsel was saying that, I looked up our interrogatory to make sure that I was clear what we had requested. And what we had requested is, so interrogatory number 6 asked for, identify and describe any and all instances in which Marilyn Taylor, the roommate, at any time verbally and or physically threatened, abused, assaulted, battered, and or otherwise attacked anyone in the building or on the premises of the ManorCare Health Services Akron Nursing Home, including the date, time, and location of each incident of abuse, the names of the victims and the witnesses of each incident of abuse, and a description of each incident of abuse. So we're just looking for information about this resident because our argument and our theory against the nursing home is you put a violent resident in a room with my client and she tried to kill her.
But what do you do with the trial court giving more than you asked for?
Trial court did not give us medical records. That was the only part of what we requested that they exempted. So they just gave, I mean, the trial court just granted our motion, so it goes back to our request. They didn't give us.
Well, he read it, and I thought I read it in the brief too, that was also with other individuals in the nursing home.
I think it's just interactions that Marilyn Taylor had with other individuals.
Maybe it's just the wording.
Yeah, so we're not looking for, you know, if another resident beats somebody up, I mean, that may have some, you know, evidentiary value, but that's not the focus of this appeal. The focus of this appeal is to get documentation of Marilyn Taylor. But as evidence of the fact that this is just about delay, we don't have an answer to anything.
Well, your interrogatories, did you say, identify any other situations in which this particular roommate has injured another resident?
Yes, so the interrogatory
What was
answer.
the answer to that?
They never answered it.
Okay.
They never responded. And so then we filed a motion to compel, and the only thing they said in response to our motion to compel was, it's physician-patient privilege. That's it. That's all that's before this court. 3721 wasn't even raised with the trial court. You know, that's being raised now as some new argument, and obviously there's a clear exception to that argument. You know, the Roe case has no relevance here. The Roe case dealt with medical records, and the Roe case said, you know, the Roe case, they were looking for all documents of abortions performed on underage girls. And the Supreme Court in Roe said, look, these girls aren't even accused of doing anything wrong. They're not wrongdoers. In this case, we're looking for the assailant's records. We're looking for a person who committed a crime. And so that's a clear distinction to Roe. And we're not asking for, well, we're not getting medical records.
You don't, have you agreed that you don't want the names of other possible victims? You're only interested in any personnel records or patient records for this one particular roommate?
Well, again, since the only privilege being asserted is physician-patient, if, you know, first of all, I think it's waived because it wasn't raised timely, but let's assume it's not waived. If the defendants, you know, I mean, they haven't carried that burden, so how could the court rule that any document is a physician-patient privilege? There's a procedure that has to be followed. You know, first of all, it has to be disclosure just made by the patient or the physician. Second of all, for the purpose of diagnosis or treatment. Third of all, not disclosed to anybody else. You know, let's assume that the roommate, let's assume that Marilyn Taylor beat the crap out of some resident, and let's assume Mrs. Jones goes to the doctor with a black eye, and she's telling the doctor about it, but her husband's in the room. It's not privileged. There's a third party who's not part of the privilege, and so the privilege is destroyed. You know, that's the whole point. You can't just slap these things with quality assurance or privilege or just, you know, it's all physician-patient. No, you got to follow a procedure. You got to come forward and say, listen, here's a document, and let me tell you, court, why this is physician-patient privilege. Let me explain to you. Let me offer you proof that this was a disclosure from the patient to the physician for the purpose of diagnosis or treatment, and nobody else knows about it. That's not what we're talking about. You know, we're talking about incident reports and nurses' notes and documentation from personnel files and all manner of places where nursing homes document incidents involving resident. And, you know, we're not getting her medical records, although I think that decision's over the broad. We just can't appeal it right now. If there's a nurse's note in Marilyn Shepard's nursing home chart that says she punched her roommate, that information is discoverable. And the way we get it in this case is we've asked for the information. So even if under the court's current ruling, we don't get that medical record, they are obligated to give us a verified interrogatory answer that says Marilyn Shepard, you know, assaulted resident number 4. Now, am I asking for the names of those residents? I absolutely am, because names are not confidential medical information. You know, everybody knows that Mrs. Jones is at the nursing home. Everybody who takes care of her, everybody who comes to visit her, everybody who sees her. A name is not confidential. And so, you know, if Mrs. Jones is coherent, she's a potential witness in this case, and if she's been assaulted by Marilyn Taylor, then yes, I'd absolutely like her names. I'd like to talk to her. I'd like to talk to her family. And if she was assaulted by Mrs. Taylor before Etta Harris was assaulted, that's my whole case. You know, think about what the defense is arguing. Marilyn Taylor has beat up 10 residents, but I can't find that out as I try to hold them responsible for trying to kill Etta Harris. And why not? Because it's physician-patient privilege. It's not physician-patient privilege. If an aide saw it and she made a statement, that's not privileged. If a nurse saw it and she made a statement, that's not privileged. If it's in an incident report, that's not physician-patient. If it's in a nurse's note, that's not physician-patient. You know, none of that stuff is privileged. You know, this is a tiny little privilege. And like I said, having reviewed literally millions of pages of nursing home charts, I can tell you, you know, there are very few pages in a nursing home chart that are physician-patient privilege. You know, if a nurse called the doctor and said, Dr. Jones, Marilyn Taylor just beat up Mrs. Smith and she's got a broken arm. That's not physician-patient privilege, that's a nurse-doctor communication. So the statute is very clear, and the statute, because it's not a part of the common law, the case law clearly says that the physician-patient privilege is to be strictly construed against whoever is asserting it. So it's to be very narrowly applied, and without any documentation in front of this court, it can't be applied. Because you haven't been offered one document that might be privileged, because you haven't been offered any documents.
So is it really just premature then?
Well, it's not premature, it's a desperate attempt to delay this case, and I would say having gone through this appeal, they have taken their shot, they have failed to carry their burden, as often happens. The appeal should be dismissed, the defendant should be sanctioned, and we should get on with this case and get these records.
And your position is you don't want to take depositions?
Your Honor, I haven't been able to take one deposition, because I don't have one piece of paper. I don't have one personnel file, I don't have one patient care policy, I don't
What about
have
employees?
any employee personnel files. We requested.
Do you need the files to start a deposition?
Absolutely. You know, Your Honor, this case, I spent up to
I
100.
realize it's not ideal,
Well,
but
Your
you
Honor,
can take a deposition of people. How long have you worked here?
That-
What do you know? Have you seen other incidents?
and that plays right into the defendant's hands. I spent up to $100,000 per case on these nursing home cases.
I understand
And that's
that.
doing it in a somewhat efficient way. If I've got to depose everyone twice, I'm going to go out of business. And why should I have to when the personnel files are clearly discoverable? Why don't I have Nurse Jones' personnel file?
Well, there are other mechanisms to solve that.
Well, but the mechanism is a motion to compel that's been delayed for a year by a frivolous appeal. That's the whole point. You know, I asked for this discovery. It's clearly discoverable. They simply ignored my request for 6 months. The court pointed that out, granted my motion to compel, ordered them to peruse the stuff, carved out the medical records, and yet we're still here.
You don't even have a list of the employees for the nursing home for the past 5 years?
Well, part of the problem is we can identify some employees from records, but for example, Aides rarely chart by name, so we can't identify them. We ask for punch detail reports and schedules to get that stuff. We haven't been given that stuff. Nurses chart, but oftentimes the nurse's note is signed, so I have no idea who it is. Don't have schedules to match up with the nurse's notes. So some people have been identified, but very few.
In your time.
And so that's what we do, is we try to get the written material so we can identify the appropriate witnesses to take their depositions. Thank you, Your Honor.
Thank you.
Thank you, Your Honors. The discovery requests were submitted on November 26, 2013. The due date was January 26 of 2014. It's clear that they weren't responded to by March 4th. That's not 6 months. It's December, it's January, and it's February. It's 3 months. He keeps standing up here and saying it's 6 months and 4 months after the court's deadline. It's not true. There was a delay. It happens. We talked about how voluminous the requests were in our brief. They filed a motion to compel. They brought it to the court's attention.
And you sat down and had a conference about how to resolve this before fighting the paper war?
Well, he filed a motion to compel. That was
Well,
coming up.
did you try and enforce the discovery rule that says before you go off and have a war, sit down and talk about it?
What I would say is, dealing with Mr. Dixon, that it's been tried over and over and over. He forces these issues. We're not trying to delay anything. We want to try this case. This isn't some conspiracy. This isn't some attempt to make him run up his cause. I know, but I have to hear it. Today I have to read about the briefs. He stands up here and asks for sanctions. He tells the court that nursing home records aren't medical records. He opened and closed with that. It's the most incredulous argument I've probably ever heard any oral
I think
argument.
the argument is physician-patient. Now, did you argue anything besides physician-patient?
Yes, we cited Biddle in there. We cited the Medina case. We cited HIPAA. We cited case law for the authority that Ohio is actually much more restrictive than HIPAA is, which leads you to the 3721.13 argument.
Well, and that's what the trial court said too.
Right.
That's the reason why she said no medical records.
And these things, you're right, and that's the issue. To pretend like there's no issue. Oh, then you say, well, if you have a law, then it doesn't apply. A court order is not a law. There's no exception on that basis.
And you're out of time.
Okay,
That's all right.
thank you very much, Your Honor.
All right, thank you, gentlemen.